subsection of the rules that we're going to discuss is the lawyer's duties to the public in the legal system. This subsection of the rules makes up 2 to 4% of your total MPRE examination. The first rule that I would like to touch upon here relates to voluntary pro bono service. So here the language of the rule states, every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono public legal services per year. So to reflect on that rule, to be clear, according to the ABA model rules here, which are going to be tested on the MPRE exam, it is good to know that pro bono work is in fact voluntary. These rules are giving you an aspirational goal. They're telling you we should all aspire to provide or to give 50 hours of service a year, but we do not have to. The next rule from this subsection that I would like to discuss relates to serving in legal services organizations. The language of the rule here says, a lawyer may serve as a director, an officer, or a member of a legal services organization apart from the law firm in which the lawyer practices, notwithstanding that the organization serves persons having interests adverse to a client of the lawyer. However, the lawyer shall not knowingly participate in a decision or an action of the organization if, 1, participation in the decision or the action would be incompatible with the lawyer's obligations to a client under the present client conflict of interest rules. So just to stop there, this is saying that you as a lawyer can work at a law firm by day and be helping out or participating in a legal services organization by night. And this is true and permissible even if, the clients or the interests of your clients related to your law firm and the legal services of the organization are adverse to one another. That is okay. But the rule goes on to state that you should not participate in some sort of decision-making process if that sort of decision is going to be incompatible with your obligations that you owe to your clients of the law firm. In other words, if they amount to what would be a current client conflict, you shall not participate in that type of decision. The rule also states that when the decision or the action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to the client of a lawyer, then again, the lawyer should not participate in that type of decision or action of the organization. In other words, it cuts both ways. We do not want the lawyer to participate in actions on behalf of the legal services organization that harms that organization's clients to benefit its clients of the law firm. So to give you another example of this to be clear, let's say an organization wants to pass a zoning law that would be incompatible with the wishes of a lawyer's client. Here, the lawyer should not participate in this type of decision or process or action. Or if the lawyer's participation in a vote would actually have an adverse effect on a client of the organization, but could be beneficial to the lawyer's personal clients, the lawyer should refrain from participating in this sort of decision or action as well. The next rule that I would like to talk about is all about law reform activities that can affect the interests of your client. So here the rule says, a lawyer may serve as a director, as an officer, as a member of an organization involved in reform of the law or its administration, notwithstanding that the reform may negatively or positively affect the interests of a client of the lawyer. So I'm going to stop there. We're talking about law reform here. So let's say you are a lawyer, specifically a criminal defense lawyer, and a lot of what you do is representing people who get, DUIs or they get pulled over for drunk driving. You can represent those clients and defend them against those drunk driving charges and simultaneously be participating in a law reform activity trying to have stricter drunk driving laws. This is totally fine and ethically permissible. I know at first glance it might feel funny, but it is permissible. And this is because your participation in this law reform activity is not going to affect your current clients. Changes in the law are not retroactive. So that's why you could do this and not have any sort of ethical issues stemming from that action. The next part of this rule says, when the lawyer knows that the interests of a client may be materially benefited by a decision in which the lawyer participates, the lawyer shall disclose that fact, but need not identify the client. So to give you an example of this, let's say the lawyer is participating in some sort of law reform activity where they're helping draft, some sort of law. And they know that by redrafting of the law in a certain way, it's going to benefit their client. Then this lawyer has the obligation to disclose that. In other words, the lawyer has to disclose that he or she has clients that will be benefited by this type of change. But the lawyer does not actually have to disclose who their client is. And then the final rule in this subsection that I would like to cover is all about the criticism of judges and other sorts of adjudicating officials. So here the rule says, a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or the integrity of a judge or some sort of adjudicative officer, a public legal officer, or a candidate for election or appointment to judicial legal office. But it's good to remember here that lawyers are allowed to freely express their experiences with and about judges. For example, if you have some sort of opinion based upon your own experience with a judge, you can express that. What this rule is attempting to curb or is prohibiting is people just haphazardly spreading false information and information that they know to be false about judges, for instance. So that wraps up this subsection of the rules.